Okay, I want to welcome Todd Blanche to For the Defense. Everybody knows who Todd is, and he's the first guest on For the Defense to appear twice. So welcome to the show, Todd.
That is an honor. Thank you very much, David. I really appreciate it.
So, I mean, you were a federal prosecutor. I'm sure you never could have imagined this when you were first starting out as an assistant United States attorney. How did you get here, Todd? How did you end up representing Donald Trump and being in trial in the first of its kind case?
Well, no, you're right, David. I'd never imagined, even during the trial, I would kind of check myself occasionally and be surprised at where I was every day. I've had the opportunity to represent a couple of folks over the past 4 or 5 years that were kind of in President Trump's orbit. And once the DA, there were rumblings that there was going to be an indictment in January, February 2023. I had a conversation with him. I was actually skiing with my family on Super Bowl Sunday in Colorado, and he called me, and we had a good conversation. I went with my wife to have dinner with him and his wife a few weeks later, and we clicked. He's an enigma. He's an interesting guy. Everybody in this country, most people in the world, frankly, have a opinion about him, and some may be right, some may be wrong, but he's a really interesting man, and not only because of his past as president of the United States, but just the life that he's led. And so we got along very well. We still get along pretty well, and so I think it's an interesting attorney-client relationship. But no, I'm as surprised as the next guy. I went to night law school, so here we are.
So you're on the slopes and you get a call, and it's actually Donald Trump on the phone?
Yeah, well, we had finished skiing for the day. We're getting ready to watch the Super Bowl with my daughter and her friends, and we were at a little condo right at the base of the mountain, and I got a West Palm Beach number. I didn't know he was going to call. I was shocked. I didn't think anybody would believe me, so I grabbed my daughter, and dragged her into the room that we were, my bedroom, and put President Trump on speaker for a minute so that she would, in case he never called me again. So, but anyway.
That's amazing. I wish I had like a 10-second clip of when I was meeting with you guys in that room, because
Right.
I believe I don't think anybody believes that either.
No, I mean, listen, and I guess that's the point of why we're talking today, but at the time there was no indictments, right? And so it was all this potential, and everybody was shocked at even the idea that a former president would be indicted. We've all kind of gotten used to it because there's 4 indictments, but at the time it was something that was certainly unheard of, but it was also something that nobody thought was going to even happen a year ago. So we've grown up, or woken up, I guess, when it comes to that over the past year. But yeah, you're right. And then when I met with you, David, and several other folks with him, I think there was a state of shock amongst the criminal defense bar at the time that I think we're no longer shocked. But at the time, I think there was a lot of shock at what was happening.
Absolutely. Even just the surrounding, like, being filmed going in to meet with a client was a first for me. But so Todd, let's talk about the case itself, because, folks are fascinated. I know you've done a ton of interviews about it, but, a lot of the interviews are political interviews, and I want to talk about the case itself. So, jury selection. Did you guys do focus groups for the case?
We had a jury consultant who was great. She was really, really wonderful, and we did a fair amount of work going into it. And but it's funny because all the cliches that you and all of us use during our careers about the type of juror that you want doesn't necessarily apply to President Donald J. Trump sitting in Manhattan courtroom. Some of the aspects of it did, but so we had a jury consultant, and we did a lot of work on the questionnaire. We really wanted a written questionnaire because we really wanted to have the time to look over the responses from potential jurors, and that, we didn't get that, but the judge did do a very lengthy questionnaire that gave some fair amount of insight into the jurors. But what I said to people the past couple of days and for the past month is the most shocking thing about this jury selection was that the judge made the decision, which I don't think it was the wrong decision, that rather than meet with every single potential juror to find out why they couldn't be fair and impartial, if a juror, after hearing that it was President Donald J. Trump, thought that they couldn't be fair and impartial, they were basically just excused. And that was done to save time, and I understand why that was done to save time. But what the result of that was is that half the jurors left.
Wild.
So imagine you're representing somebody, and 100 people walk in the room, and 50 bounce before there's even a single question because they can't be fair and impartial. Maybe not quite 50, but 40 bounce, let's say. And then the ones that, so the answer back might be, well, half stayed, Todd, so find your jury. But then when we would get done with the questionnaires and we'd have a little bit of time to do some research on the potential jurors, many of the jurors outright hated the president, Right. And so it was something, man. Like, I think we'll talk about this for a long time, the jury process, but it was very challenging.
Were you able to do like the background research in real time to find out, what social media they were on, all that kind of stuff?
Yes. Well, we got lucky. We had overnight after the first night, and then we had a pretty long time after the second night. And so we were able to do a fair amount. But listen, our system is not built for this. So, for example, David Markus, potential juror, I look on your social media and I see that you've had several negative comments about President Trump. And we had one juror who literally had a video of her dancing in the streets in Manhattan when the 2020 election was decided against President Trump. But the question that the judge is required to ask is, okay, well, so putting aside what we see, do you think you can put that aside and be fair and impartial? And if the answer is, oh, yes, absolutely, we're kind of stuck.
It's crazy. That's crazy. Of course, you could use a peremptory, but that person should be, struck for cause.
Oh, yeah, and it should be struck. And New York is very, it's by statute, the number of peremptories. We did not have a lot. You get your peremptories, and that is it. And you don't get them. You don't get to keep them, you waive them if you don't use them. So we had some very difficult choices to make, and here we are.
I'm surprised that we haven't seen more of the jurors on TV being interviewed and coming out and talking about the case. They have been very quiet.
Amazing. We're Sunday, the verdict was Thursday, close of business, and we very much expected even the alternates. So there's 18 jurors, 6 alternates, all of whom, stayed true through the trial. And we haven't heard unless something happened today, I don't think we've heard from jurors. It's amazing.
Have you been able to speak to any of them after the verdict?
No. I mean, remember, we don't have their information. So we did have it, but we had to destroy it, and we did destroy it, so I don't have any way to contact them, even if I wanted to.
No, sometimes they reach out to the lawyers, right? I mean,
sometimes they do. I don't know if I would be able to tell you if they did, but okay. I guess I can show my hand and tell you they have not. So
okay. So one thing that was interesting to me, Todd, is that they were not sequestered. And I mean, talk about a case where there was a little bit of news coverage. Should the jury? Did you ask for them to be sequestered, and should they have been sequestered?
I mean, it's a great question. No, we didn't ask. The New York law is really, really tough on that. And it would have, I think, not been something that would have been possible under the law. But I agree with you. The judge was really disciplined every day about telling them to not basically open their phones. I don't know. You had folks who had roommates, spouses, of course. I don't know if we'll ever know how that played. President Trump, as you know, was very vocal about his displeasure with the trial. It was on every single cable, but also regular news channel every day. And so, one thing that smarter lawyers like you would have maybe done differently that we didn't do is think about whether to kind of, at some point during the trial, poll the jury and ask the judge to say, guys, is anybody seeing anything? The reason why we didn't do that is because the risk of saying, don't look under that, don't look
Right.
under that, that hidden, is that they would do something. So I don't know, but you're right. It was crazy. Like, look, you and I grew up. I mean, think about like the big trials before, like O.J. Simpson and some of these trials. This, I suppose, was like that, but on steroids. But there was no cameras in the courtroom, right? So it was something.
Should we have cameras in the courtroom? Should we have had cameras?
Can I become the interviewer? What do you think about that?
I think we should. I've been a big proponent of it. I would have liked to have seen the openings, the crosses, the closing. I think people would have been, instead of just relying on different reporters to describe how it was, I think we should be able to judge for ourselves.
I always have said no, but having lived through the past 6 weeks, I could not agree with you more, because people that were in the room said things that were completely false, right? Much less people that were not in the room, and what they would do, David, and I don't know if you've experienced this in New York, but for 1 minute before the day started, the pool photographers could come in and take pictures, not video, but pictures of President Trump. So we would sit down and be trying to get ready for our day, and all of a sudden 4 or 5 photographers would come in, and we'd have to sit there, making looking normal for exactly 60 seconds while the camera went off, and then they would leave, and that was it. That's all you got.
It's weird. That whole pool photography thing was weird. And I have to say, even the sort of press conferences after court, I felt a little bad for you, Todd. You had to stand there with a straight face behind your client. What was that all about?
Look, I felt, I mean, listen, I still am very passionate about this case. I feel stronger than anything I think I've ever felt professionally in my life, that this is not a case that should have been brought. And I wanted to be serious. I wanted to make sure people appreciated that I was not, and I was, and it was, he needed to talk at the beginning and end of every day. He has a message that he has to get out to the folks that are going to vote for him or not vote for him. And so I stood next to him, and I wanted to be next to him because I did want to make sure folks realized that he wasn't alone, that he had a team. And my daughter, my wife, my mother-in-law, they all don't like that face. But what are you gonna do?
It was funny because you're such a personable guy, and we've gotten to know each other. And people would see the face, and they'd come to conclusions just based on your face outside, because that's all they'd see. They didn't see you in court.
Right. That's right. That's right.
It's crazy. So let's talk about opening, Todd. So opening, you start out, of course, you call him President Trump, and you make a point to tell the jury that he deserves to be called that. Tell us about that decision to come out and call him President Trump like that.
Well, that was my decision. I wrote that in the opening because I knew that there would be some witnesses who referred to him as President Trump, but most would not. It's proper. There's some different views on the internet about what you're supposed to do, but it's certainly not improper to call, just like you would call Secretary Clinton. You get judges that leave the bench unless they're in court are still often referred to as as Judge so-and-so. And so I think, President of the United States is by far the most important office you can hold in this country. And I think that it was something from the first time I met him that out of respect I used. And I just wanted the jury to know that it was nothing more than that.
Did you think it was disrespectful that the judge called him Mr. Trump instead of President Trump?
No, I don't. No, and so did a lot of the witnesses, and so did the government. I wasn't about throwing stones at them for that issue. I mean, I think that it's a different. They had a different view. We were kind of unwavered that we're going to refer to him as as President Trump because of the title he had.
So, part of our job is, of course, to humanize the client. And, starting a couple days into the trial, lots of folks started to come and sit behind you all and President Trump, including his kids, including friends. The press made a big deal about, that, of course, you would have been criticized had nobody showed up either.
Yeah, yeah.
I thought it was weird that you got criticism for people coming to watch and support your client.
My reaction is the same as what you just said. There are a couple days when there weren't a lot of people there, and there was some criticisms. And then when folks would show up, it was like, oh, it's a political. People are just doing a dance, and that is not the way that I took it. Look, people don't appreciate. You appreciate it. And I think a lot of your listeners do. Being on trial is awful. You know, it's a long day. There's no breaks. There's people talking about you in front of you all day long, whether it's the judge, the witness, the government, or even your own lawyers. And so, and having folks around him that supported him was priceless. He had friends that showed up, every day. His family was there every day. Some didn't come to court. They would just stay at his house and be there in the morning when we got there, and be there when he got home at night. He has a great group of a support group that was really amazing during that trial. But you're right. And on the one hand, we get a lot of benefits because he has Secret Service protection. Like, we get to go right in and go right out. But it's also a challenge. Like, he can't leave during the day. He can't go out and get a fresh air. He's stuck in this like ante room off the courtroom. It's a tough situation.
So you said some stayed at home. Obviously, people made a big deal about his wife not being there. Was there a discussion about having her there to support? Because of course the jury's going to watch everything and see that she's not there. Was that discussed?
That wasn't a discussion that I wanted to have. I mean, she's obviously their son was finishing school in Florida, and I don't think that the lack of presence should be interpreted as a lack of love and support. It's just a lack of presence. So, no, I mean, listen, this was a tough case because of the nature of the charges, the evidence that came in, the history, that how long it had been. And I think President Trump tried to do the best that he could for his family, and honestly, I think he did a really good job with that. But it was tough.
Yeah, no, I can imagine how hard that is, and hard on you too, Todd. I mean, did you tell me about your routine? How much sleep did you get during the trial? Like, did you get at least 4 or 5 hours a night, or no?
No, but it wasn't me. I mean, Emil Bovie's my partner. Susan Necklace was there with her team, and we all worked very hard. And it was as every trial. I'm not suggesting that there's anything different about this trial than every single criminal trial that everybody that we all do during the year. What we would do is Emil and I, my partner, would meet at Trump Tower every morning and spend 10-15 minutes with President Trump, going through what was going to happen that day and understanding what concerns were and that sort of thing. And then we would ride down with him to court. And then after court, I live very close, and our offices were very close to the courthouse. So we would just go to work. And it's interesting, Judge Merchan has always had his maybe not always, but for many years has had his calendar day on Wednesdays, which is pretty great. I mean, I don't know. So you basically have Monday, Tuesday, and then you have a day off, and then Thursday, Friday, and then the weekend. So for a trial lawyer, you have Monday, and then Tuesdays, and you get a day off. So that was nice.
So you liked having the Wednesday off. Like, sometimes, yeah. I've heard some people like to just go straight through and get and go.
Well, I don't know who those people are, but we loved Tuesday night when you had a day off the next day. That was great. It let us get ready for the rest of the week, and But it was, listen, man, this was the hardest I've ever worked in my entire life.
Are you going to get some time off? Are you going to take a little time because you have all these other cases coming up? Are you able to at least catch a breath?
Not really. Emil and I are we have motions to compel in Florida, a 3-day hearing, evidentiary hearing in 3 weeks. And a lot of that, we have Section 5 notice in our SEPA case. So that requires a lot of time in the SCIF in Florida. So we're going to head down there this week and get, so unfortunately there's not really any time off. And not to get ahead of ourselves, but that's going to be a very busy month. We have motions in the DA case as well, getting ready for sentencing. And then at some point in June, the Supreme Court's going to rule in the January 6th in the DC case. And depending on what they do, there could be a hearing, there could be, you know, something else that in July or August in DC. So it's going to be a rough summer.
It's wild. You don't get a break. Todd, you mentioned you lived close to the courthouse. Were there security concerns? Were you threatened? Was it dangerous to be involved in the case?
Yes. No, there was a lot of, I always say, David, I get, you know, 50 emails a day, 25 want to kill me, and 25 thinks that I'm the greatest thing they've ever seen in their lives.
Right.
So there was a lot of support from folks. But what happened was we would leave the first 2 weeks of trial, nobody knew who we were. And then by the third, fourth week, it got a little tough. But I've been part of this district since 1999. So I know my way around Chinatown. So I just snuck around Chinatown and made my way home.
So it's funny because I tried a case in New York in federal court a year and a half ago, and everybody was telling me where I should stay. And I wanted to be walking distance from the courthouse. So I stayed at a little hotel in Chinatown, which people thought I was crazy, but it was great because I could walk to the courthouse and I got good Chinese food every night.
Every night. No, listen, I loved it. I have no complaints about that. And you know, the Secret Service agents are great. The court security was amazing. Like, these guys were super, I mean, they were dealing with just an incredible amount of pressure and stress for the past 6 weeks. And we always felt safe. You know, we always felt like everything was going to be okay. But it was something.
So, but everybody seemed nice, but the judge did seem a little hard on you guys. And, you know, as criminal defense lawyers, we're used to it, right? We're used to the judge being pro prosecution in these cases. That's the way it goes. I will say, like, you know, just some of the things that I read about, you know, how it was freezing in the courtroom. I had Donna Rotuno on as well, and she represented Harvey Weinstein. This was one of her big complaints in the same courtroom. They wouldn't make it warmer for her. But, you know, I mean, was it freezing in the courtroom?
The first week it was ice cold. It got a lot better.
Okay.
And it wasn't, by the way, I mean, it's not really anybody's fault, right? Like, it's that building is so freaking old.
Yeah.
And it's such an odd setup. But the first day, the first couple of days, jurors, the court reporters, one woman came in full parka, like literally full parka head to toe. And it is hard sitting in a room that's freezing cold. You know, there were some improvements made on that score, so we got better. But yeah.
Okay, good. What about the prosecutors? Did you get along with them during the trial, or was it like no communication at all with those guys?
Look, we had a lot of communication, and I am not, you know, I wouldn't say we got along during the trial. That there were some things that as a former prosecutor, I saw that I objected. You know, they didn't tell us who the witnesses were until.
So I wanted to talk to you about that, because everybody was saying, "Oh, that's just a courtesy." That's BS. It's not it's something done in every single trial that I've been a part of, where the prosecutors tell you who the witnesses are the night before, and if they don't, the judge orders them. I've never been a part of a trial where I didn't know who the witnesses are, and you cannot prepare for the next day unless you know who the witnesses are.
It was the single most strategic. It made our jobs harder, I think, than anything else. And you know, the reason they said is that President Trump had threatened witnesses, but he was under a gag order, and we agreed not to tell him. Right. So we said, just tell the lawyers, and they still wouldn't tell us until the day before, sometimes late in the day. And so, and you're right. Like, by the way, Title 18 United States Code Section 3500, by the way, requires you give the material after the witness testifies. But there's not a judge in this country that would ever tolerate the federal government turning over materials that late. So it's, even though the CPL in New York doesn't require, there's not something that requires it, that was something that I was most certainly not prepared for. And so here's how it ended up happening, though. As you can imagine, we divide up witnesses amongst the defense team, but we do that not knowing the order, and we guessed wrong, because Emil in 1 week had like 4 witnesses in a row, and then Susan would have 1, and then I had 1, and then Emil had 2, and so you have a poor Emil working, you know, 21 hours a day for a week, and then the next week he has no witnesses. He's like, I don't want to assist. It was
Crazy. So
man.
yeah, it made no sense to me. And I was surprised at folks saying, oh, that's not a problem. Even, this is the problem with the case. I think it creates even criminal defense lawyers taking weird positions that you would expect them not to be taking. This is a perfect example. I mean, I was surprised to see some of the criminal defense lawyers saying, oh, that's just a courtesy.
I was too. It's interesting. I was hoping we would talk about this because that's one of the biggest, not the biggest, but that has been surprising to me is a lot of the folks that I've known for years that have complained about the government, right, being heavy-handed and doing things or not doing things. When it came to this trial, they were like, nah, I think it's totally fine. I got no issues.
I was surprised. I was surprised at that, Todd. I was also surprised. I was going to talk about the press a little later, but some of your former colleagues from SDNY going on TV who knew you and still criticizing you. Did you see that? And I mean, it must have stung to hear some of those guys talk about you.
For sure. I mean, I don't, and I have tried to be a really, fair lawyer my entire career, both when I was a prosecutor, but also since I left. And a lot of times it was obvious to me that the people who were criticizing hadn't read the papers, right? So there was, they'll remain nameless, but there was a time when somebody commented extensively about a brief that wasn't public. So the judge hadn't let it be filed yet. And they were commenting on how frivolous it was. And I knew that they were wrong. They were literally making it up. Literally, and this person was a very high-ranking Department of Justice lawyer who's now, a legal analyst, and that kind of thing, I don't know if I'll get over. And I don't say anything. You said I've done a lot of interviews. I don't do any interviews. I did 24 hours of interviews, and then this podcast, and then I'm going dark again. But that was tough. That was tough.
Yeah, I did say that at the beginning, and you're right. You amazingly did not speak to the press before the trial, during the trial. It was only right after the verdict you spoke to a couple outlets, and then of course this podcast, which we're very appreciative. Let me talk to you about speaking, because the gag order was a big deal, obviously, in the trial. And first of all, there's been talk about whether the gag order still applies. It would seem to me it doesn't, right? Because it shouldn't apply because there's no more witnesses or jury. Does it still apply to Trump?
I don't know. So the short answer is, admittedly, I think you're right. I think it does not apply. But we don't have. I'm very sensitive to not. The original order, I think it would not apply, but then it was expanded, and there's some language in the expanded order that we need to kind of make sure that we're not violating the judge's direction. So I think you're right. It should no longer apply now that the jury is over. And the gag order was a really big challenge for us. I very much, it made during the trial, it made our work much more challenging because we have a client who, President Trump has always wanted to speak his mind in ways that a lot of people don't like and a lot of people do like. And so when the judge said you can't, and there was some things about the gag order, right? Like, so, and I don't know where folks land on this, but reposting articles, for example, he was violated for, right? And I think everybody, you could have intellectual discussions with First Amendment lawyers and probably come out on both sides. But for me, that was pretty surprising when there's no commentary. If you were to write an article that said something about, Michael Cohen, and then he reposted that was a violation. So it was tough.
And one thing that bothered me about the gag order is witnesses like Michael Cohen were allowed to go on TikTok and say whatever they want, and then Trump couldn't respond, which, if the idea behind the gag order is not to intimidate witnesses, I mean, it would seem like it was over-inclusive, right? Because a guy like Cohen wasn't intimidated, and it seemed weird that he should be able to speak about Trump, and Trump couldn't respond.
And by the way, the D.C. Circuit in the gag order that was affirmed, so Judge Chutkan's gag order was actually scaled pretty significantly back by the D.C. Circuit, and they talked about that. Like, so in that case, take someone like Bill Barr or Vice President Pence, someone who doesn't need to be protected, right? They recognize that there could be situations where it's appropriate for a defendant who's gagged to be able to respond. And we very much wanted to do that, you know, especially with respect to Mr. Cohen and Miss Daniels, because remember, at the very cusp of the trial before it was adjourned, I mean, she had a documentary come out 5 days before the trial started. That, and we weren't allowed to talk about it. That was pretty tough for President Trump and what he was doing and the campaign and whatnot. But listen, you know, it's in effect, or it was in effect until Thursday, and that's the rules. So
one of the interesting things to me is always developing a defense and a defense strategy, especially in a high profile case. And I saw that you spoke about how you and the former president did this together. I mean, was that difficult, Todd? Because it seemed like you took on a lot in opening and in the trial. And in a lot of cases, you know, we want to, as defense lawyers, just pick sort of one theory and let all the other noise sort of, you know, not make it important. It seemed like you had to take on a lot in this trial. You know, for example, that he never had a relationship or sex with Stormy Daniels. That was a big talking point, you know, in the press about why did you have to take that on for a trial like this? Is that something you guys landed on together, or how did that work?
Yeah, definitely together. And you're right. This was, look, this was not a regular criminal trial, right? So it was not the usual thing, or we say, listen, let's just give that away. Let's ask her no questions, right? That's perfect. Because then we can say in summation that her testimony was irrelevant, right? That was just simply not an option because, first of all, you know, President Trump has always denied that happened, and that wasn't a trial strategy. That's something that he said since 2011. And so, and also, you know, dealing, you know, it's interesting. I haven't really taken a breath and thought it through, but you know, he's every single juror knew him very, very well, or at least thought they did. And so the usual, like, pick a defense strategy and, like, you know, try to protect your clients so they don't find something out or do find something out, like, that doesn't, you know, the government introduced tweets from, you know, 2017, you know, like, that we had all seen before. The jurors were not seeing those for the first time. You know, that's an incredible, you know, place for him to have to defend himself from. So, but no, look, our trial strategy, maybe enough people will tell me that I screwed up that I'll change my mind, but it was the right one, right? Which is that Michael Cohen, there were a lot of corroboration around Michael Cohen that included witnesses who were never called, right? Alan Weisselberg and Dylan Howard and you know, folks that were part of conversations that the government was talking about repeatedly, but they didn't call the witnesses. And you know, I think that was the right strategy. It's tough.
Let me ask you this, Todd. The war room got a lot of play. You know, people took a picture and saw the candy and stuff in the war room. Was it McDonald's for lunch every single day, or did you get something else?
Oh, no. Well, first of all, I didn't have lunch one day because
you didn't eat during. You have to eat during the trial. No. What do you mean?
I ate in the morning and at night. Well, so the food. Look, the President Trump's team takes care of everybody. Like, everybody gets food. You know, there's a lot of food. It's not always McDonald's. There's a variety. There's pizza and there's other non-healthy alternatives to McDonald's. But look, I loved it because, you know, you come in from lunch and as you know, when you're on trial, you're trying to figure out what the heck you're going to stuff in your belly with the hour that you have. And we would walk in and there would just be just plethora of, like, just food everywhere. But I always take trials as an opportunity to lose a few pounds. So, you know, it's my own little way to
Did you lose weight?
Yes, absolutely. I think I lost, well, I haven't weighed myself since the verdict, but 7 or 8 pounds during the trial, you know, so.
Let's talk about some of the witnesses. I don't want to keep you too long, but just some of the witnesses. So Stormy Daniels, I mean, you made the decision to have Susan Necklace cross her. Was that, did you guys say that a woman needed to cross her? Or was that part of the decision making there?
Yes. I mean, look, Susan, I don't know if you work with her. She's
awesome.
A rock star. She is such an amazingly smart criminal defense attorney. And so I think that was kind of always the plan. I don't know that whether the fact that she's a woman, that was a factor, I guess, maybe, but really, she's really, really good. And she's, like, just worked with her when I was a prosecutor and she's a defense attorney, and I started working together obviously a little over a year ago, and she started up. She's good. She knows what she's doing. She knows how to ask the right questions of the government. So that decision kind of just presented itself, and then I wanted to cross Michael Cohen, and then the other witnesses we just kind of divided up. I mean, Emil and I, and Emil, Susan, and I just kind of figured out who should cross which witness, and we did it in a way that would give each other's breaks. But like I said, that failed miserably. But
I would have liked to have crossed Michael Cohen, man. I mean, talk about a dream
No.
cross. I mean, let me ask you about that cross. So you started out the cross asking about whether he called you. I forget what it was. And then there was an objection and it was sustained, which I was surprised about. Why was that objection sustained? Because it seems like it does go to his bias against you.
I actually, the first exhibit I wanted to introduce was the next question. He had gone on a podcast after the trial started, and it said on the podcast, see you soon, Todd, you little fucker, and he flipped me off. And to me, I thought that made it, that was really showed a real deep bias, right? He doesn't know me. I don't know him. And so I asked the first question, which is when he called me like a little shit or whatever he called me. And the judge sustained the objection. We went up to sidebar. It's not sealed. It's part of the record. He said, "Don't make this about you." And I said, I'm not making it about me. It's about his bias. And he just said, don't make it about you. Move on. And he shut down, and judges have a lot of discretion. So I'm not trying to be critical of Judge Rashan on this, but there was a lot of areas of cross that I thought really went to the heart of his deep bias against the trial, but also against Trump. And we got enough in. I'm not saying he didn't let us cross, but there was a lot that was shut down too.
Were you surprised that he was able to keep his cool, at least for most of the direct and cross? Did you think he was going to lose it a little bit?
No, like I don't know. Look, he's a savvy guy. I listened to every one of his podcasts the past 6 months, and
I'm so sorry.
I listen to yours too. So I like yours. Yours are. I run to yours. When I was training for the marathon, I was run to your podcast. So look, I don't. Listen. I'm not gonna get in a battle with Michael Cohen. And I crossed him in areas that I thought was appropriate. I think that he. I said something at the end of my summation that got me in trouble, but it's the reason why I said it. It became like a mantra of mine to anybody that I've talked to over the past year, which is that I very much believe in my soul that you can't rely on Michael Cohen to send somebody to prison. And I should not have said that to the jury, of course, but the reason why it slipped is because I've said that to anybody who would ask over the past year, because I actually believe that with a passion. He can do his thing, right? Like, he's a savvy guy. He's got his podcast, he's got his Twitter feed and all that. But like, it's different when you're putting somebody in potentially in prison. And that,
why shouldn't you be able to say? Why shouldn't you be able to say that? That's always bothered me. I mean, it's not like it's a secret. I mean, you shouldn't you be able to say this man's liberty is at stake, and here's what the government's relying on to put him. Why I don't see why people freak out about that.
It's interesting because there was a judge in Southern District who overruled my objection on that very issue, and he said exactly what you just said. You don't think that the testimony of the cooperator is going to, and the judge got very, very frustrated that I had said that. And by the way, there's always an instruction in every jury charge that says, I'm responsible for the sentence. You're not. So, but listen, that happened. So
last witness I want to ask you about, Costello. I mean, he and the judge, man, just went at it. And the judge, I mean, threw everybody out of including the press. I mean, what happened there with Costello? Was he just had a bad day, or what happened with him?
So I couldn't see him. The way the courtroom's set up, you can't, even President Trump and myself, you can't see the witness from where our table is. Emil was questioning him, and what the judge saw was basically him not following the judge's instructions, whether the objection sustained or overruled, or answer the question directly. And listen, you can't do that. You know, like whether you're a murderer who's testifying on a cooperation agreement, or someone like Bob who's been a lawyer for a really long time, like the judges run their courtrooms, and that's not unique to Judge Merchan. That's I think what us trial lawyers know more than anything in the world is, and he was very, very frustrated. It was the end of a very long trial, the end of a very long day, and you know, I think Judge Merchan wanted to just make sure that the rest of the evidence that came in from Bob, you know, came in clean without any extras. It was a pretty incredible moment, though. You had the press, and those court reporters crushed it. I mean, if you haven't seen the transcript, it's amazing. The court reporter, she heard every single press. Why do we have to leave? Our lawyer's here. And then, I'm the lawyer, I want to stay. They crushed it. Like, they got every single thing going out. There's like 3 pages of just single people yelling, and the press was very, 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 very upset.
They were right. They should have been able to stay. I mean, it was pretty wild that they got kicked out. By the way,
totally.
the next day, Costello's back on the stand, and at least the press report, I haven't seen the transcript, that Costello said something to the judge, and the judge looked like he acknowledged it. Do you know what Costello said to him?
I saw the same thing and didn't hear. I couldn't see. I don't know what was said. No, and it's not on the transcript.
So there was a big deal, of course, about your client saying he was going to testify, and then he didn't testify. I know you've spoken a little about this, but what was he prepared? Like, was he prepared to testify, and that was a last minute decision, or how did that go down?
It wasn't last minute. I mean, look, everybody that's listening here that's done a trial with the defendant knows how that process goes, and this one wasn't much different. Look, the judge made decisions under Sandoval, which is a New York, you know, the New York way. The judge said to say which evidence can be crossed on, and he was going to be able to. The judge gave us some, but he was going to be able to be crossed on a lot of stuff that would have been way too complicated to answer without opening doors, right? So, you know, take the AG trial. So he limited the cross to not ask about the fine being 500 million. But part of the answer to why President Trump thinks it's a completely unfair case is that the judge fined him $500 million, right? So then he would open the door, and then it all comes in, and that was tough. And look, it's a very personal decision, I think, to him and with counsel, like it always is, and it wasn't a last minute decision. I think it was a decision that we were making together along the way, but it's his decision. You know, it's funny, like I think he's a super savvy guy, and he saw what the judge had let in and not let in, and you know, and that was kind of it.
Is he regretting that he didn't get up there? I mean, I would think that he was, you know, obviously you play the result sometimes, which is too bad. It was, you know, right decision at the time, but now is he saying, shoot, I should have gone up there and testified?
I don't know. I mean, I think we maybe as time goes on, that kind of thing will pop itself up. Look, we made decisions as a defense to really not call any witnesses. We called Bob and my paralegal, but look, there was folks we could have called, you know, our general counsel from Trump Org, and Don and Eric, and folks that maybe had information that could have shown a little bit different story. And you know, you make decisions in trial that
of course,
that you know, you Monday morning quarterback, and you should have done something different. But.
Of course. By the way, a lot of people reported, and again, this is one of the reasons I would have loved cameras in the courtroom, but a lot of people reported, you know, Trump was sleeping during the trial, things like this. I guess 2 questions. One, was he sleeping? And 2, or was that just a way to send a message to the jury that none of this was bothering him?
No, he was not sleeping. And I think eventually the press realized he wasn't sleeping. His eyes would be closed, but he would be concentrating. And I know that to be true because he would write me a note and make it clear that he heard what was happening. So I don't think he was trying to send a message to the jury either. You know, listen, sitting in court all day is really freaking boring, even if you're the defendant. And I don't mean that disrespectfully to anybody. It just, they're long days. And so, you know, they're long. And so you're sitting there and you have a witness testifying about phones and what the phone showed. And so he would close his eyes to relax, but we never had to wake him up, you know.
Talk about long, Todd. The closing, the summations were so long. I'm specifically the prosecution's like 5 hours.
Yeah.
I mean, it's hard to sit. I couldn't sit. People can't sit through a 2-hour movie anymore, like 5 hours. That's nuts to me.
No, it was really long, and Josh Steinglass is a good lawyer. He really is. I have a lot of respect for him, and he had what he felt like the jury needed to hear, and he wasn't gonna. And the judge. I mean, it's on the transcript. During the day, Josh went up to the judge and said, "Judge, can we stop and come back in the morning?" And the judge said, "Nope." The jury said they could stay. And then 6 p.m. he said, "Judge, can we stop now?" And the judge said, "No, you're going to keep on going." He's like, "I think I have 2 more hours." And the judge said, "Well, then I guess we're going to 8 o'clock, aren't we?"
Wow.
Like, it was pretty, listen, that's, the judge really wanted to be able to just get everything done in one day. To be fair, frankly, to us, that's why he did it.
Right.
So,
But this whole thing in the closing about you going first and the prosecution, getting to go second without you responding. I've never seen anything like that. It's a weird quirk in New York State Court where the defense goes first. I imagine you hated that, right?
yeah, of course.
Yeah.
It was really tough. And it's in the statute, it's like, that's the way it goes, and it's unique. I mean, listen, a lot of people say the same thing about rebuttal in the federal system, that you just get beat up for 30 minutes by the feds in rebuttal. But it was tough. It was a long day, and we lost the trial. And so obviously the jury certainly accepted Josh's version of what happened over ours. But yeah, it's a quirk.
The other weird quirk to me is that and this is more than a quirk, this seems unfair, but the judge said you couldn't discuss the jury instructions in your closings. And then, then he reads these 50 pages and then the jury can't even have them sent back. So what's the thinking about not letting you discuss the instructions in closing? To me, in every closing I've ever done, I put the instructions up on the screen and I walk the jury through them.
Yeah, no, that's his rule, and he applied it equally to both of us. When I talked about the law, he shut it down, and when the people talked about the law, I shut it down. But you're right, especially in a very technical case. I mean, David, not to get sidetracked, but remember, the false business records is a misdemeanor. It's elevated to a felony if it's to cover up another crime. The crime that was covered up that they eventually settled on is a misdemeanor conspiracy crime to commit election fraud, which requires unlawful means. The unlawful means that they proved there were 3 separate crimes: tax crime, another false records, or federal election violations. That is complicated even to say to a lawyer, right? Misdemeanor crime. It's tough,
It's really tough. And I've seen a lot of folks talking about how it's never been used in this way before. Are there good issues surrounding that for the appeal?
I hope so. Look, we have really good appellate issues, and there's not a criminal defense attorney in the world that wants to ever say that out loud. And I'm saying it now, but of all the cases that I think that we have right now, Florida, DC, this case, even Georgia, there's some really prickly issues that happened with what we just talked about, the statute of limitations, with the recusal issue, some of the stuff that happened in discovery with what we think were pretty blatant discovery violations. There's a lot of appellate issues. So, but as you know, getting conviction overturned, it's not easy. So
there is hope, because a lot of folks didn't think Harvey Weinstein's appeal would get overturned, and so there is that last thing about the closing. So you called him the MVP of liars. I love the gloat line, of course.
You loved it because you gave it to me, David. Say it to the world. It was genius. It was genius.
So it was. Did the jury react to the line? Did they like it?
I think they did like it, and the MVP of liars too. Like, I was trying to personalize it more to them. Like, what can ring true? Like, this person has not told the truth under oath on many occasions, and he also lies to people that he loves. Please don't trust him. And so the gloat that you let me borrow, I think, resonated with me, and I think it resonated with them, at least in perspective with all the other evidence. And he is unique. I mean, he did lie to, and my wife actually gave me this line, which I said afterwards. I said, he's the gloat. I said, he's lied to every branch of government.
I love it.
Which is incredible. Like, both houses of Congress, the DOJ, and also the judge. So that's another, like, but I try not to use a lot of cliches. I don't think jurors really like them. And I did use those too, but it was a 2.5 hour summation, so I don't think I should be accused of just
No.
cracking jokes the whole time. But
So by the way, the gloat line, I steal from everybody else, which I love to do. I stole that line from a great guy named Robert Hirschhorn. So I gotta introduce you guys because Robert came up with the line and then I stole it and then I gave it to you. So it was good. I don't know if you've seen Michael Cohen since then, but he's gone on the air and tried to turn that around and go after you. Anything you want to say to Cohen about that or no?
I absolutely not. I don't have any desire to fight with anybody. I'm not that kind of a lawyer, so no, I did not.
Let me ask you this: you said on the air last week that you and the former president did prepare for the verdict. To me, the toughest thing to do is to prepare a client for a bad verdict, and every lawyer has to do it, right? That's a tough conversation you have to have.
Yeah, no, it was tough. I got to tell you, and I said this, I think, in one of the interviews, but I actually mean it. I have a lot of conviction on this. I thought he was really, really strong on Thursday. And, everybody likes to talk about the way that he reacts to things and that he doesn't, he yells and says things, that maybe reacts too quickly. He was, we knew when the jury came back, and it was a last minute thing. We were pretty sure it was a conviction. There really wasn't any doubt in our minds. And I said to him, some version of this today doesn't define you. It doesn't define you at all. And let's just let the American people and your family and everybody who's watching, how you're going to handle this. And he did. He stood there, I think, and heard guilty 34 times. We went outside. He spoke to the press about his frustration, but overall, for somebody who had just gone through what he went through, I was like, it sounds maybe a little bit obnoxious to say, but I was like really, really proud of him on that day. Like I felt like, he just did the right thing for the process. And we are fighting, right? We are appealing. We do not think this should have been a conviction. We're going to fight all the way to sentencing. We're going to fight after sentencing. And so it's not as if we're just rolling over to the opposite is true. But I do think that the way that he handled the verdict was something that I was very proud of, and I think that hopefully that the American people are proud of that too at the end of the day. But it was pretty surreal.
So Todd, there's nothing worse for a criminal defense lawyer than of course hearing that kind of verdict, and I've been there many, many times, and it takes something out of your life. I mean, being in a trial like this, that itself takes years off your life. Then hearing a verdict like this, what I was surprised about, because I posted a little something saying, no matter how you feel about Trump, like you got to feel for the lawyers who put their life into this, and work so hard. And I was surprised that criminal defense lawyers commented like pretty aggressively about that comment that I posted. I was really taken aback by that, and I'm sure you've seen it on a level times a million, but I was surprised by that.
Yeah, like listen, I wish that we could all have a conversation as criminal defense lawyers at some point about. I've said this to you, I think, the last podcast, but I feel very passionate about it. It cannot be that defendants like Jeffrey Epstein, the defendants like even Hunter Biden, right? Who, and I don't mean any disrespect, but they can have big law represent them, and the big law lawyers get awards. They get to go to galas. They get to speak. They're posting on the LinkedIn how amazing they are. But that if you're representing somebody like the former president of the United States in a white collar case, that I have to leave my law firm and lawyers, you're right, like lawyers who I know have spent their lives complaining about over-aggressive prosecutions, prosecutors that shouldn't be brought, and prosecutors that don't do the right thing during cases with discovery are just, calling me saying I had frivolous motions. It's something, man.
How about these same lawyers who are, progressive lawyers saying he should go to jail at sentencing when, first time nonviolent offender in his 70s on the lowest level felony? On anybody, name any other name besides Trump, they would be saying obviously no jail time, and now they're calling for jail. At what? I mean, it must drive you bananas.
Totally. I mean, there's a couple of legal folks, legal pundits who are, again, DOJ, former DOJ officials who, when President Trump was president, railed against the idea that you would go after your political enemies, you know, because there was some scandals that during his presidency, and now they scream from the rooftops that the 4 indictments against him is not going after your political enemies. It's just you know, following the facts, doing the job. You know, I think as a legal group, criminal defense attorneys, at some point there will be it might not be for a couple years, but we'll realize that maybe this wasn't the right way to handle these cases. But in the meantime, you know, I'm gonna go to Florida and start the next one on Tuesday. So
I see, Todd, on the video, you know, you've got a few more gray hairs than you did when I spoke to you last, man.
Totally.
You're catching up to me. I mean, this must have just absolutely changed your life.
Yeah.
And so I hope you take care of yourself. I hope you know, that you're doing okay. And I just really want to thank you for doing this, because, you know, I know how busy you are. I know how swamped you are, and it means a lot to me. And I think people will get a lot out of it that you were willing to come on and talk to me for an hour about the case.
I was happy to do it, David. And I mean, in all seriousness, to you, I know a lot of people that have worked with you. I know a lot of people who know you very well. I now consider you a friend and someone who I know pretty well. You are by far the best out there, and I'll always say yes to this podcast. It could be the first 3-peat.
Let's do a 3-peat. You're gonna win the next one and come on after the next one after a victory.
Done. That's a deal, David. Well,
Thank you.
very
Thank
much,
you so much, Todd.
Right.
Thank you so much.